Now, the exclusive information we have about Kelsey Fitzsimmons. I began, I think Saturday morning, I learned a little something about what was happening. As folks know, they filed an emergency petition with the SJC, the Supreme Judicial Court of Massachusetts. It was a request for what's called a single justice review. They have 7 on the court, but you can say, hey, give me one justice. We want fast action on this. And they did. They got some fast action. Denied. The request was made to overturn Judge McCarthy's decision that if Kelsey Fitzsimmons, who was shot during the altercation, which is the underlying matter in this case, if she couldn't do the scram, the breathalyzer alcohol testing required by terms of her release. Yeah, it's kind of like this, but not quite like this. If she couldn't do that because of the pain it was caused as a result of the injuries, then she's certainly much safer in jail. That's when the court sent her to jail. That spawned the emergency petition. That led to the single justice saying, no.
Dewar.
Yeah, just Dewar. Yes, Ms. Elizabeth Dewar, the Honorable.
I had such hopes for her.
I know. So let's see how that all shakes out, because the exclusive tidbit is a notice has been filed now to have this matter heard. I'll say en banc, although you usually use that in the context of a decision by the court. This is a request to the court, meaning the entire panel. And it's part of the process in Massachusetts. It's unusual, again, because so is a single justice request. That's a bit
so that motion has been fired. So exactly,
notice,
it was fired?
Yes, and I mentioned on the weekend that I thought it was coming, and I have confirmation that it was filed. There should be a follow-up memorandum of sorts. But as I mentioned on the weekend,
so what is it called? What is it called now? What's this motion called?
It's basically it's a motion. It's a reconsideration in the form of a petition for the entire court. And what they do is they look at the existing paperwork that's been filed. So whatever memorandum there may be, whatever follow-up there may be, probably not much more than a reference to the original filing. I don't think you're prohibited from filing more, but I think in general it is based primarily on what you have already filed, which also helps it be a little speedier.
So it's kind of like the federal court. When I go up to the federal court and I have a 1 judge or a panel of 3 judges decide, I can, and there's a 2-1 decision, let's say, because there's a split, I can ask for a hearing en banc for all 9 justices of the appellate courts, the circuit, what they call circuit courts, the federal courts, to hear that petition that I have. And then they get to vote on it. If 5 votes to say they will hear it, they will all hear it, and there'll be an en banc decision.
Yep. And unlike the Supreme Court of the U.S., SCOTUS, as they say, it's not really discretionary. The court today just decided not to hear a case. I can't remember the guts of it, but it was announced that they had not decided. It was a high-profile case. They said that we're not going to take it. In this general situation, they don't really have that option. Basically, they could deny it, but it's almost a merits denial rather than we're not even going to look at it. So here's the rule, okay? Here's the basic rule. Appealing. This is your basic rule 2.21, appealing from single justice denial, okay? Here's one of the caveats, okay? And it'll lead us back to the single justice's decision. When a single justice denies relief from a challenged interlocutory ruling in the trial court and does not report the denial of relief to the full court, I don't know by reporting if they mean, officially or what. The party denied relief may appeal the single justice's ruling to the full court unless the court otherwise orders. The notice of appeal shall be filed with the clerk of the Supreme Judicial Court. In this case, it was for Suffolk County, but Essex is the same. Within 7 days of the entry of the judgment appealed from. I was speculating over the weekend that 7 days, it's safe to consider that to be calendar days. If you start thinking, well, it's probably just business days, I got till the end of the week, then you may screw yourself. So I believe it's calendar days, and the notice has now been filed. And that highlighted part is critical. Unless the single justice or the full court orders otherwise, neither the trial nor the interlocutory ruling in the trial court shall be stayed. So in other words, doesn't help Kelsey Fitzsimmons immediately. Unless there's some
she's not leaving jail unless and until they decide to take this en banc and make a decision.
Yep.
That reverses what we've heard.
As it says here, well, let's see if I can find out. There we go. The appeal shall be presented to the full court on the papers filed in the single justice session, including any memorandum of decision, 9 copies of the record appendix, which must be filed in the office of the clerk for the Supreme Judicial Court for the Commonwealth. That's obviously 7 for the justices, maybe 1 for the clerk, and 1 for the hell of it. The record appendix shall be accompanied by 8 copies of a memorandum of not more than 10 pages. I like that, how they limit the bloviate nature of some of these filings. The appellant must set forth the reasons why review of the trial court decision cannot adequately be obtained on appeal from any final adverse judgment in the trial court. They got that nailed since they made a motion for reconsideration. Right. No response from the prevailing party shall be filed. And that's interesting, right?
Right. That's great. Actually, that's
unless requested. The court could say, hey, we need some of this.
Right. But the whole point is that it's supposed to be very clear from your papers that you need relief, and we don't want to hear from the other side. By the way, speaking about people that are watching us, Michael, but before you go on, Madeira Beach caregiver, I just want to give a shout out to. She's actually been a member for 10 months. She says actually a year, but after YSL, she renewed her membership under Madeira Beach caregiver name, and she's arriving in New York City to celebrate David Bowie in January. Wow. Hopefully, New York City will still be here. We hope.
Well, let's see. If the new when do they? I think the new mayor takes over like in December, right? Like the November election and December 1st, it's the new mayor. That's what I recall.
Yeah.
So yeah, you're right. There's gonna be a full month under communist rule. We'll see what happens. And I don't know, David Bowie, would he like that? Oh, he's not around anymore. What's the event? NBC. What's the event? Tell us.
Tell us what the event is.
Yeah,
we need something to celebrate, because when we're talking about we're talking about this here. One of the things, have you seen the reasons for this appeal? It seems to me that, we were all excited with Judge Dewar. I was really excited with Judge Dewar. And by the way, I have been invited back to Harvard.
Yes, there's been a mistake. There's been a mix-up in the mail.
On the adjunct trial advocacy workshop in January, that first week in January again. So you'll probably need a guest host for that week, but I am going back to Massachusetts, and it'd be interesting to see what judges are.
Maybe they'll stack you up with Judge Bev. That would be the best.
She's actually in the 3rd week. I'm in the 1st week. The
who
judges
knows?
usually are. Judges are usually, but who knows? The first time I was actually there, with also another first timer, and her name that I was sitting at the lunch table. That's the first time we meet. Was Judge Ketanji?
Oh, Jackson.
Brown. Jackson. Yeah. Yes. So who knew that I was going to be sitting with a member of the future Supreme Court? I have you.
You
and
could
they
be the next
have
one
each other.
Talked about for the Supreme Court. You're rubbing those elbows. You're rubbing those elbows.
I was asked to be a judge early on in my career, and I said never in a million years. While I could be very judicial, I'd probably be one of the best judges in the world. I would never want to do that.
If you don't say so yourself.
I would know if I don't. No, I would be, because I'd be fair. I try to be fair.
You try to do the right thing, I think.
I try to do the right thing.
But you couldn't take the pay cut. So, that's the tough part. Okay, let me finish this.
There is wearing those black robes every day.
Yeah, well, you can wear with some nice pearls. Let me finish this before we move on. Okay. Number 4, remember, with the U.S. Supreme Court, the default position is, no, we're not taking it. We only take a handful, right? It's the opposite with this. The full court will consider the appeal on the papers submitted pursuant to this rule, unless it otherwise orders. So their default position is, we're gonna take a look at it. So that's what we hope should happen. I thought I saw a time provision on here. Whenever you put expedited, it's kind of a crapshoot as to what that means. But they did act pretty quickly, unfortunately denying, but they did act pretty quickly with the original. So we'll see what happens when this goes up to the full load of 7.
Well, that's it. And I was praising them. Remember, I told you they have some of the greatest opinions on forensics in the United States. They're usually forward thinking. But and I know we're going to talk about her reasons for denial, because I was shocked. I just don't think she quite got it. But Madeira Beach caregiver decided to answer you.
Good.
Bryant, David Bowie was born in 1847.
I cannot believe it's been.
I can't believe.
My brother-in-law is
I can't believe it.
He is a major fan. We went to there was an exhibit in New York not too many years ago. It was after he died, but not maybe 3 or 4 years ago. There was a real experiential kind of exhibit for David Bowie. We went to that because he's a major fan.
Well, I didn't know annual event in the cutting room. We did not know that. So maybe
there you go.
Maybe you want.
Maybe that's where I went.
Maybe that's where you want to bring your brother-in-law.
And he's in the Philippines now, so I'm not going to bring him.
Yeah, not going to bring
draw the line at the international date line. That's
okay.
it.
777 Texas. Member for 5 months, almost half a year. Love spending time with you. We love having you. I know it's a very welcoming community here, except when it's not. And that's usually because if we get attacked, we tend to attack back. But that's just us, you know. We don't suffer fools. Well, I guess is the way we should be saying. Where did that come from?
I don't know. Is that
I don't remember.
I don't know.
Yeah.
Shakespeare, the Bible. I don't know.
Michael Bryant.
No, that one is not mine. I got a couple of axioms. I cannot claim that one.
Yeah.
So that's where we are. Let's do this just to refresh recollection, and let me see if I can find it, because the one quick caveat about being able to bring that matter to the whole court is, hey, well, what about the single justice? Did she do anything to preclude that from happening?
Right.
Which would really be
really interesting. That's a really interesting thing in the rule, you know?
Mm-hmm. And you can see that not only did she not do that, because it would have been laid out separately, but in this footnote, she says, as the Commonwealth notes, nothing prevents the defendant from requesting relief pursuant to the same provision if and when the defendant can make a showing that information exists that was not known at the time of the hearing, or that there has been a change in circumstance. We know that's not going to happen for a number of reasons. That's why they're going the route to have the entire Supreme Judicial Court take a look at it, because I think the position of the defense is, if we next appear in front of Judge McCarthy, it's going to be to get her bounced. And so,
I said that to you because you know what she would do if you appeared in front of her and said, "Change circumstances, I can now breathe." She'd probably haul their asses all off in jail, including the attorneys at this point, because she's not going to take that. I mean, I just think she'd be waiting. Even if she did take it for 30 seconds, in 60 seconds, she'd put her back in jail. Okay, there'd be some reason. She didn't even give any credibility to their own probation department who does this for a living every day in and day out. You know, so how much experience does the Judge Dewar have? She hasn't been on the bench that long.
No, I looked at her bio last time. She's been on the bench since January of 2024, but her background was not as a judge. Her background is primarily, she was a trial attorney for a while. Then she clerked a lot. Among others, she clerked for Justice Breyer for the Supreme Court. So more academic's probably not the best way to put it, but it's kind of more academia than in the trenches, right? Okay. And so she really hasn't had a lot of experience as a high-level judge or at the trial court level either. So,
or as a trial attorney, then apparently.
Yeah, just a little bit of that. She was with a firm early on, it seems, and then she went into the clerking role for everybody.
Yeah, and then she was attorney general for a while, I think. When
she filled in for, I think it was 23, maybe, and not to besmirch clerks, because clerks do a lot of the opinion writing.
Yes, I know that. Clerk ones for
and so they're doing the grunt work, behind the scenes, and then obviously the justice they work for is signing off on it and guiding them and all of that. But the clerk is not just like bringing
that's how you learn
clips and staplers.
No, that's how you learn about the standard of review. That's how the judge.
Oh, I'm glad you mentioned that. I'm glad you mentioned that, because in this particular
why I
case,
mentioned it for a purpose, because that was one of the first lessons I learned.
She screwed this up. Justice Dewar screwed that up, because we knew going in, having read the law, that the standard of review should have been de novo, meaning you look at it anew, new trial. Trial is kind of in quotes because it wasn't truly a trial, but new, which means you can entertain evidence that was never presented before. And she used the phrase abuse of discretion, which is a version of review, but not this one, not the right one. So abuse of discretion was inappropriately applied. So I don't know if that means, she's just not experienced, or she just purposely misdirected people. I don't know, but she used the wrong standard. And here's another thing that we've talked about before.
Explain to everybody what de novo is.
Well, de novo just means new. I mean, of new, meaning
new eyes.
Outside things can come back in. You're not limited to the record from below. That's the bottom line. And speaking of the record from below, we were wondering, she references very specifically. Let me see if I can find it here. I just put this doc away, but I think it's worth taking a look at again. Check this out. She says up here, following close review, blah, 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 the Commonwealth's opposition and appended materials, including transcript of the hearing, transcript of the hearing.
Transcript. Here
Now,
we go again.
That made me think, that's pretty specifically identified. If she listened to the audio, and everybody who has is pretty sure that Judge McCarthy is out of her brain. But if you didn't listen to it and you just looked at the raw transcript, maybe you don't get enough of that impression. We know that Tim Bradel supplied a thumb drive, right? Which was the audio of the hearing. Now, here's the situation. She agrees that she looked at a transcript of the hearing. We know that they submitted a thumb drive of the audio. I can't make the leap to think, well, then she must have listened to the audio. I do not assume that at all. So
I don't assume it because, as I've told you in the past, that many courts don't use the audio as the record. They don't consider that it's the record. The certified record. The certified record is a transcript, and you find that in many courts. We found that even when you want to give a closing statement of courts, and you ask the court to use, let's say you and I are the pool cameras, and we're streaming, right? And we want to use a clip of somebody sitting on the witness stand to remind the jury what they said. A court will say sometimes, that many courts will say you can't do that. That's not considered the record. I had that happen in Massachusetts. That's the case in Massachusetts. I've had that happen in California, where the judge did allow it, but then instructed the jury that it's only the transcript that's the record. So, it depends on the court. And I have a feeling Massachusetts doesn't consider that, court TV or long crime or justice served TV, pool camera coverage as, or anybody else, Boston 20, anybody as the certified record.
And it's interesting too, because I think, I'm not 100% sure, but I believe that recording was not a media outlet. I think it was the court system, which suggests that if you're going to take anything, wouldn't you take the court's
That's what
internal
I
system?
would think. That's what I would think. I would think that's even better because the person who was transcribing from the court system is certified and they're listening to the transcript. That's Boston 25. I'm sorry, not Boston 20. So,
yeah, I think we already know your answer to this.
Yes.
I gave it some serious thought, and to really determine whether I wanted to or not. I did judge like some beauty contests. I did, but okay.
So that leads us into when we said we were going to do this show. All right, all of you know that we all have personal lives, and we interject our personality and our feelings into how we view things. So that we always say the show is law, crime, justice, mixed in with a lot of Michael Bryant's humor and a lot of my fashion, right? That we do. And I see that in comments. Somebody said, what is this, a fashion show? Yeah, well, sometimes it is. And on that note, I will point out there's been some talk in the chat about my lipstick, Common Sense Investigator. Now, if you watch the Jimmy Auntie Deb that I do with makeup, I'm really big for layering. So what this is something called Atomic Cherry Red. I forget who makes it. It was something in an Instagram feed. I liked it. I bought it. Okay. And then I wipe it off. And then I put something called Luminescence pink powder over it to dab it up. And then I put my standard MAC Angel lipstick over that. So you have three things here going with my lipstick. I know somebody else wanted the details. That's the details, everyone.
That's a whole hell of a lot of work. I personally have my Blistex, which is a lovely one. This flavor is I think it's Mango Blast, which is lovely.
Oh, yum!
Delicious.
Yum.
Domino likes this when I put this on. It's very fruity. So where were we going with this? So we'll obviously tomorrow. I'm thinking we may have the memorandum that goes along with the notice of further appeal. I will call it. It may have something in it, may not. Don't know. But I think back to our issue with the transcript and whether she listened to the audio or not.
Right.
She may have thought in her mind that listening to the audio was beyond what she was allowed to do, because in her mind it was not a de novo review, or at least if it was, she didn't say so. She could have easily said, I was provided the audio but did not listen to it because the standard here is abuse of discretion, not de novo. That would have been flat ass wrong and easy to spot. But we can just second guess, well, why would you not say including hearing audio recording of the hearing if you actually listen to it? So
Yeah.
Thank you.
Yeah. And also the fact that she said that there was not an abuse of discretion, which is really interesting to me.
Yeah.
Why use that? You say my review that there was no violation of the law and the judge was within the rights to do this. Period.
And that's why with any appeal, when you're doing the paperwork, there's a subheading for standard of review.
Right.
You very clearly, you cite the cases to it, and for whatever the case may be, it's either abuse of discretion, clear and convincing, or whatever it may be, or de novo. So,
all right. So my fashion has gone a little bit astray, but let's Joyce Behar.
Yeah, I've been wondering this myself.
You take a tissue and you blot the first lipstick. That's the Atomic Cherry Red in this case. With this something a brand I don't normally use. You all know that I tend to use Chanel products on my face and my lips. You blot that, and then you put the powder over this luminescence powder. It's a pink powder. It's by the way, you'll see it all over the place. If you start buying it, it'll be coming to you in your Instagram, your Facebook, or whatever. But it's a really great pink for layering and for blotting. And then the Angel lipstick just goes right over that.
Whew. I'm telling you right now, I'm so glad I'm not a girl or a woman, lady. That's just so much work. I'm telling you, I get
so much fun.
I got a haircut last week, and it was traumatic. So it's just that's a lot.
So why don't we go back to here, because let's go back to the law, because we do have something to offer, because we are lawyers and have had all these cases and all. I understand this judge was just the lower court judge is just pisses me off. Okay, just pissed me off. I've been in that situation. You're supposed to be fair, and I think I've said to you in the past, watching this decision and watching a number of things that happened in the Karen Reed trial just were unfair. And I'm watching Perry Mason right now, right, or Matlock, I guess it is right now. Matlock. Things are supposed to be fair. It's supposed to be fair. I want it to be fair. It's not fair anymore. And it's just.
And it's that fundamental fairness that slaps you in the face, and you think, well, why don't they see this? And if they do see it and don't care, why are they still on the bench or a prosecutor or law enforcement? How do they get away with that? We're seeing some cracks, when we see a proctor fired. Okay, but look how bad that had to get. That had to get outrageous before it actually happened. So. And
not only that wouldn't have happened if the feds hadn't gotten involved for the issue of corruption, because this has to do with his personal phone. And if you want to go get a personal phone as a lawyer in any case, so you want to save evidence in a case, the judges aren't going to give you access to the personal cell phone of the cops in a case. They're just not. The feds got that, and that's how he's into this. Or else that's why right. Why do you think he was using it for all these years?
Of course, and they being the authorities would be right in denying that request, because it should be just for their official phone.
And
so you're right.
The judges would slam you as defense attorney and saying you
can't have that. And so because of that, these folks are using their private phones. Maybe not as much anymore. Maybe the proctor factor will help some folks. Thank you, East Texas Alice.
Now they'll just use throwaways, right? Now they'll just use throwaways. That's all. I mean, that's what's good. That's what they're going to try to stay one step ahead here. So, I mean, I just think that it's just but 12 years. I'd love to have Mike Easter on again to talk about this.
I forgot I was going to send him a note, because we were going to talk about the Cellbrite weird videos that they put out,
right,
about how our software sucks.
Right.
Remember that? Very weird. I do want to. I'm trying to remember to reach out to him. I'll make a note of that.
Yeah. Oh, no. Oh, Sweetie Note says if you use the phone to discuss work and discover anyway, isn't it? He'll never say he used the phone to discuss work. That's what happens. They deny. They say that's a personal phone. We don't use that phone. We have our just like they used to be on radios all the time, and you would get what's in the radio, but they'd have a cell phone, and the judges never gave you that. They said, well, the radios are their official cop business. You're not allowed to have their cell phone.
Oh, I predict going forward. It may take too long, but I predict what'll happen is there will be cases appealed that are based on the use of a private phone versus a company or a law enforcement phone. And there will be a process by which you will be able to get into personal phones of public officials. If there's a third party that can review the material, and it won't be the prosecutor, it'll be a true third party, so that if there is in fact exculpatory material, it will be turned over to the other side. But I think it'll take a while for that whole process to evolve. But the proctor factor is a good kick in the ass to start the process.